Good morning, everyone.
Good morning.
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 Good morning.
Ooh, there's so many people here. This is awesome. It's a popular one. Everyone wants to know what's going down. Right, we're going to get started right away. We have a few folks that are still joining us. We'll give one more moment, and then we're going to get started. So in the meantime, if I can ask everyone to mute their microphones. Mimi will be presenting first, and then what we're going to do is in between, we're going to be going through Bill 29, we're going to be going through Bill 38, but in between each section, we're going to allow for question and answers. So. Okay. All right, well, let's get started. Thank you, everyone, for joining us this morning. It's really nice to see so many people interested in this topic. We were happy to see the bill being passed so quickly. I really didn't expect that, but that day they were, I guess, I don't know, it was a few weeks ago, and I know that they held everyone at Parliament for overnight, and I think everything went through then. So really happy to bring the information to all of our members. So I'd like to just start by introducing Nimi Hamid, who's a policy analyst with the Workplace Health and Safety Branch at the Department of Labor and Immigration for the province of Manitoba. Nimi holds a Master in Public Policy from McGill University and a Bachelor of Arts in Economics from Sarah Lawrence College. In addition to her work in occupational safety and health, Nimi has built a diverse policy portfolio through roles in different sectors, including housing, accessibility, and skills development in both the global north and global south. So again, we're just going to get started here by Nimi's presentation on the amendments to the Workplace Health and Safety Act. And then we're going to open up the floor for any questions that you may have. And then I'm going to proceed with updating you on Bill 38. All right, the floor is yours, Nimi. Thank you so much.
Thanks, Jacqueline, for the introduction, and thanks to everyone for joining us today. I also have my colleague, Big Taliwal, who's a technical analyst at Workplace Safety and Health, here with us. So on June 3rd, 2025, Bill 29, which is the Workplace Safety and Health Amendment Act, received royal assent, bringing into force multiple act amendments. My presentation today will be divided into two parts. At first, I'll briefly take you over the Workplace Safety and Health Act review process, and then I'll dive into the Act amendments. I'll take questions at the end of the presentation, and my contact details will also be shared in case you want to share further questions for clarification. I want to start off with the act, with the land acknowledgement. We acknowledge that we are gathered on Treaty 1 territory, and that Manitoba is located on the treaty territories and ancestral lands of the Anishinaabe, Anishinaabe, Dakota Oyete, Denisuline, and Nehethowuk nations. We acknowledge Manitoba is located on the homeland of the Mired River Métis. We acknowledge northern Manitoba includes lands that were and are the ancestral land of the Inuit. We respect the spirit and intent of treaties and treaty making and remain committed to working in partnership with First Nations, Inuit, and Métis people in the spirit of truth, reconciliation, and collaboration. Before we dive into the Act review and the new amendments, I just want to take a moment to recognize that every year, more than 1,000 Canadian workers are killed because of the job. Hundreds of thousands more sustain physical and psychological injuries because of unsafe working conditions. At Workplace Safety and Health, it is our mission to improve compliance with the Workplace Safety and Health Act to prevent occupational injuries, illness, and death. And the Workplace Safety and Health Act review process really helps to strengthen protection for workers and foster safer and healthier workplaces for all Manitobans. So the Act review process. The Workplace Safety and Health Act mandates the review of the Act at least once every 5 years. As such, in August of 2022, the legislative 5-year review of the Act was launched, and the Workplace Safety and Health Act Review Committee was established, comprising of equal number of labor, employer, and technical representatives. And Jacqueline was also a part of it. The review committee was tasked with undertaking the legislative 5-year review of the Act and deliver consensus recommendations. The minister's mandate for the review committee included ensuring that strong protections are in place that meet the needs of today's workplaces, improving harmonization and consistency with other jurisdictions, ensuring requirements are clear and reasonable, and helping Manitoba meet its obligations under the Regulatory Accountability Act. The legislative 5-year review was launched with 3 months of public consultation, which resulted in 62 submissions containing 197 unique recommendations from Manitoba all across the province. In terms of the timeline, the review committee conducted its review session from January 2023 to December 2024. During this period, the Act Review Committee evaluated the public submissions, considered relevant legislation and information from other jurisdictions, and analyzed Manitoba-specific information to develop recommendations for each submission. The Act Review Committee recommendations were shared with the Minister in December of 2025. Bill 29 was introduced on March 6th. The bill proceeded to its second reading on April 17th. It reached its third reading on June 2nd, and finally on June 3rd of 2025, the bill received royal assent, bringing into force 17 amendments to the Workplace Safety and Health Act. For today's presentation, we'll focus on 10 of the 17 Act amendments as suggested by Manitoba Heavy Construction Association because they would be most relevant for this group. The next few slides will share details on each of the 10 Act amendment topics as you see on the screen. Before I do that, I'll provide a brief snapshot of the 10 Act amendments. The Act amendments include for psych safety, a definition of a psychologically safe workplace has been introduced in the Act. Interpretation of dangerous work under the right to refuse dangerous work legislation has been added. The authority of the Chief Occupational Medical Officer to order medical surveillance has been expanded. Now, associated employers can be treated as a single employer. Clarification has been added to specify that safety and health officers can deliver orders via email or electronic methods. Orders must remain posted in the workplace till complied. All risk assessments must be conducted by a competent person. Failure to report serious incidents can result in the issuance of administrative penalty. The terminology accident has been replaced with incident. And finally, clarification has been added to inform that the obligations related to seasonal workplaces also apply to temporary workplaces. We'll start with psychological safety in the workplace. So for this, enabling workers to work in a psychologically safe workplace has been added to the object and purpose of the Workplace Safety and Health Act. The Act states that a psychologically safe workplace is a workplace in which the psychological well-being of workers is promoted and active measures are taken to prevent harm, whether negligent, reckless, or intentional, to the psychological well-being of workers. This definition aligns with the CSA standard on psychological safety in the workplace, and psychological health and safety related regulations are anticipated in the near future. Right to refuse dangerous work. Under the Workplace Safety and Health Act, a worker may refuse to work or do particular work at a workplace if they believe on reasonable grounds that the work constitutes a danger to their safety or safety or health, or to the safety or health of another worker or another person. A new section on interpreting dangerous work in right to refuse has been added. This is to help ensure that the right to refuse dangerous work is understood and applied consistently. It clarifies that dangerous work is a situation where there is imminent risk of serious physical or health injury and where adequate controls have not been implemented. This section acknowledges that a hazard may present more of a risk to certain individuals. Therefore, additional measures may be needed in some circumstances to protect workers. Medical surveillance. So what is medical surveillance? Medical surveillance involves monitoring the health of workers through tests and examinations to identify possible health problems related to occupational duties or exposure to hazards. For example, depending on the type of exposure, medical surveillance can include hearing tests, lung test function, blood tests for lead or chemical exposure, and x-rays. Medical surveillance helps to identify and address potential health risks at an early stage. Early intervention may prevent further exposure and possibly improve outcomes. Previously, medical surveillance programs were only required in the mining industry. Now, the chief occupational medical officer, or the COMOS authority, has been expanded to order an employer to implement and maintain a medical surveillance program in workplaces where workers are suspected of being overexposed to a harmful substance, for example, asbestos, lead, etc. If new information becomes available after an order is made, the COMO, or the Chief Occupational Medical Officer, may reconsider the order. The procedure for reconsidering order is determined by the COMO. If the COMO collects any information about a worker under health surveillance programs, that information must stay confidential and cannot be shared with anyone unless the law requires it to be shared. The information is shared in a way that does not identify the person, or the person gives the person gives permission for it to be shared. I just want to go back to the previous slide. I also wanted to add that the order that the COMO issues, it must be served on the employer personally, or be sent by registered mail to the employer's last known address. If a medical surveillance program is ordered, it must be developed by the employer in consultation with a physician. It must be periodically reviewed in consultation with the Workplace Safety and Health Committee, a representative, or the workers themselves if no committee or representative exists. A worker cannot be subjected to a medical examination under the program without their consent, and the employer is responsible for ensuring that all personal health information of workers is protected in accordance with the Personal Health Information Act. Moving on. This slide is regarding related employers being treated as a single employer. Previously, Workplace Safety and Health has encountered some employers who changed their names in an attempt to evade enforcement or penalties. For example, instead of complying with an order or addressing a hazard, the employer may close the business and reopen it under a new name. Often the new company has the same directors and shareholders, operates in the same business sector, and does similar work. To address this kind of challenge, the new amendment allows the Director of Workplace Safety and Health or the Manitoba Labour Board to be able to deem associated or related businesses carried on under common control or directions by two or more employers to be a single employer for workplace safety and health purposes. This applies whether or not the business are carrying on work at the same time. The new authority basically allows the employers to be held accountable for addressing instances of repeated non-compliance of a similar nature. Electronic delivery of orders. A safety and health officer may issue an improvement order or a stop work order to the employer. An improvement order is basically a written direction order to address a situation where a workplace safety and health law is being broken. It will explain what is wrong and what the legislation requires to comply. It will also tell you the date by which you must comply. When a safety and health officer observes an imminent hazard, they may order work to stop immediately and remain stopped until they're satisfied that the hazard is appropriately dealt with. Previously, improvement orders or stop work orders could be communicated by delivering a copy directly to the person or their agent, sending it by registered mail, and if those standards failed, posting it in a conspicuous place at or near the workplace. The Act amendment introduced and clarified electronic method of communicating orders. The Act states that if the person or their agent has provided an email address or another electronic method of communication, the order can now be sent electronically. Furthermore, the Act states that an order sent via electronic means is deemed received on the date it is sent unless the sender receives an automated response indicating the message was undeliverable, or the recipient had previously informed the sender in writing that the email or communication method could no longer be used. So this change provides clarity on the timing of electronic delivery and helps ensure accountability in digital communication. Posting of orders. Previously, the Workplace Safety and Health Act stated that if an improvement order or stop work order cannot be communicated by the standard methods, the safety and health officer is responsible for posting a copy of the order in a conspicuous place at or near the workplace. There was no requirement for how long the order had to remain posted. Current legislation states that if the order or stop work order cannot be communicated through the standard methods, the safety and health officer may post a copy of the order in a prominent place at or near the workplace and keep it posted there for 7 days or until compliance with the order has been achieved, whichever is longer. Posting of reports. It's similar to the previous slide. Previous slide, it addressed posting of orders when standard methods are not applicable. This slide is about posting of reports where there is no safety and health committee or worker representative in place. So the worker requires a person against whom an improvement order is made, for example, an employer, to prepare a written report on measures taken or to be taken to remedy a contravention. Previously, the Act required that if no committee or representative exists in the workplace, the person subject to the improvement order is responsible for posting the report in a prominent place at or near the workplace. The duration for keeping the report posted was not specified. The current legislation states that if no safety and health committee or worker safety and health committee representative for the workplace exists, the person against whom an improvement order is made shall post a copy of the report in a prominent place at or near the workplace and keep it posted there for 7 days or more until compliance for the order has been received. Risk assessments. So risk assessments are a very vital component of ensuring workplaces are safe and healthy. If risk assessments are not conducted effectively, hazards may remain unaddressed, posing a risk to the worker's safety and well-being. The legislation states that whenever a risk assessment is required in any context within the regulation, it must be conducted by a competent person. The Workplace Safety and Health Act defines competent as possessing knowledge, experience, and training to perform a specific task. So for example, let's say Part 15 of the Workplace Safety and Health Regulation, which is for confined space, it requires employers to conduct a risk assessment. So when we are requiring employers to conduct a risk assessment by a competent person, with this regulation, it means that the employer has to ensure that whoever is conducting the risk assessment for the confined space, they must have the knowledge, experience, and training to perform that task. The intent is really to ensure that potential hazards are effectively identified so they can be mitigated to prevent workplace injuries, illnesses, and fatalities. Administrative penalty for failure to report serious incidents. So what is a serious incident? The Workplace Safety and Health Regulation outlines the definition of serious incident. It defines serious incident as an incident in which a worker is killed, in which a worker suffers an injury resulting from electrical contact, unconsciousness as a result of a concussion, a fracture of his or her skull, spine, pelvis, arm, leg, hand, or foot, amputation of an arm, leg, hand, foot, finger, or toe, third-degree burns, permanent or temporary loss of sight, a cut or laceration that requires medical treatment at a hospital, as defined in the Health Services Insurance Act, or asphyxiation or poisoning, or that involves the collapse or structural failure of a building, structure, crane, hoist, lift, temporary support system, or excavation, an explosion, fire, or a flood, an uncontrolled spill or escape of a hazardous substance, or the failure of an atmosphere supplying respirator. Under the Workplace Safety and Health regulation, when a serious incident occurs at a workplace, an employer is required to immediately and by the fastest means of communication available, notify the Workplace Safety and Health branch. The new amendment outlines that failure to report serious incidents or provide the required information respecting a serious incident in accordance with the regulation may result in the issuance of an administrative penalty. Replacing accident with incident, the Workplace Safety and Health Act has been amended to replace the word accident with incident. The terminology accident implies that an event is random or unavoidable. However, incidents in the workplace are preventable. By recognizing that incidents are inevitable, the law promotes better risk assessments, stronger preventative measures, and more accountability for safety procedures. Finally, there's been an amendment regarding seasonal and temporary workplaces. Previously, the Workplace Safety and Health Act stated that employers are required to set up a safety and health committee if they have 20 or more workers at a seasonal workplace for a period of 90 days or more. The review committee suggested the term seasonal could be misinterpreted. This is because some employers may assign additional workers not due to this calendar season, but due to factors such as particular work orders or increased work volume. So this legislation is absolutely unrelated to seasons. So the amendment clarifies that this rule also applies to other temporary workplaces, not just seasonal ones. So if a temporary job site has 20 or more workers and lasts 90 days or more, a safety committee is required. This amendment ensures that temporary workplaces are held to similar safety standards as seasonal ones, improving worker protection across more types of work environments. So that's about it. I've shared a lot of information and I'm here to answer questions. But before I close the presentation, I just want to say that every year, there are so many workers who face fatalities, as I mentioned earlier, so many workers who suffer injuries and, injuries, physical and psychological. But we think that every worker in Manitoba deserves to come home at the end of their working day as safe and healthy as when they left. And ensuring that is a responsibility we all share every day. Thank you once again for joining us today. Over to you, Jacqueline.
Snimi, thank you so much. Lots of information there. Does anyone have any questions? You can unmute yourself and ask any questions that you may have. I think things are pretty well defined there, but you never know. Sometimes there's interpretations.
Hi.
Hi.
I do have a question about the definition of serious incident, just because we had this come up before. So when you talk about fractures, you talk about amputations, you're pretty specific when you get to your fingers and toes. But on fractures, it just says hands and feet. Does hands and feet include fingers and toes for fractures? Be reported as a serious incident.
So I'm going to jump in on this one, Mike, just because I was part of the review committee, and the review committee report has gone to the minister on further amendments to the actual regulations. And that is part of that committee's report. I just put it in the chat. So those are, you can see that that was part of the conversation to further define exactly what you're talking about. And so take a look at that, but it hasn't passed in legislation yet.
Yeah. So
I just,
what? It hasn't passed yet, so then what does that mean?
So it means that the definition for serious incident stands right now the way it is. The only thing that changed in the act was the responsibility to report.
Yeah, so just to jump in there, Jacqueline. Yeah, this was the act amendment change, right? So 2.7 for serious incidences is under the regulation, and so regulation stuff has not been passed. But as Jacqueline mentioned, or the link that shows, it was reviewed and it was a topic of discussion.
Okay,
What he did was he basically made a jig.
Okay, so I have an RT here that
Yeah.
has their hand up. Randy?
yes, my experience for fingers and toes, I've contemplated that definition in the past, but we've always treated broken fingers and toes as a serious reportable incident. And I believe Workplace Safety Health recommends the same thing. The only thing I see under serious incident that is questionable, in my opinion, is the cuts or lacerations requiring medical treatment at a hospital. Because we've had, in my experience, we've had in the past people being treated for a cut or laceration at a walk-in clinic, perhaps. In that case, it's not a reportable serious incident according to Workplace Safety Health. But if it's at a hospital, it is a serious incident. So it's not really fluid in that matter.
Yeah, Vic, and I don't remember if that part was a topic of discussion.
Yeah, so I can touch on that a little bit, Randy. So like you're totally bang on in terms of, a cut happening, you go to the walk-in, and a cut happening, you go to the hospital. So let's just say, you're working on a meat slicer during the day and it's not that bad, and you go to a walk-in. Now in the evening shift, you get that exact same injury, exact same finger, and because now walk-ins are closed and you have to go to the hospital in the evening or at nighttime, it's reportable. Again, when you design these rules or regulations, it's hard to encompass like different situations and stuff like that. So that's why,
right?
Like a walk-in, and the reason for the walk-in scenario is typically if you're going to walk-in, it's not urgent. You can wait a bit before you get seen, right? So so walk-in is not reportable, but a hospital is, and even though you may have the exact same incident, but at different times of the day, it might be reportable.
Yeah. Okay. Thank you.
Any other questions on this part of the presentation?
I
No?
actually do have
Yep.
something more, sorry.
ahead.
The definition of what is mobile equipment on a construction site. I thought they were going to amend that to not include passenger vehicles. Mobile equipment in my opinion, is machinery. Machinery needed on a construction site, but not the passenger vehicles to arrive at the site with. And that led into what requires a fire extinguisher. So yeah, equipment, machinery requires fire extinguishers in some cases, but not all passenger vehicles.
Yeah, Vic, do you want
Yes.
to mention this one again? Because I think that was part of that report as well, right?
Yeah, exactly. So it's very similar, Randy, that the way we define power mobile equipment, because it talks about, a vehicle used for transportation or moving of workers, and a vehicle fit that definition. So like by that definition, like a Domino's pizza truck would have to have a fire extinguisher, or someone doing temporary work would have to have it. So we've now defined that you have to do a risk assessment, right? So a passenger vehicle still would fall under that PME definition, but now you're doing a risk assessment to see if it requires one or not. And I think we also aligned it with the federal rules in terms of, if it's not required, there's probably not hazardous as well for us. So.
Okay.
And that's part of the proposed amendments in the report, Vic, or is that legislated right now?
No, that's proposed, right? So anything that not anything, but the report that Jacqueline provided us to review on the regulation side stuff has not been passed, but it's been brought up and discussed. But the act itself hasn't passed.
Yeah.
Okay. Thank you.
Yeah,
And
good questions.
Jacqueline, did you share
Just,
the FAQs? Sorry. Jacqueline, did
Sorry,
you
just
share
in
the
touch
FAQs with
base. Oh.
Oh, go ahead, Vic.
Sorry, I was gonna say, did you share the FAQs with your members?
In prior, but I'm going to pull it up right now. If you have it handy, if you would throw it in the chat.
For sure.
Is that the FAQs for the Bill 29?
Correct. And I'll add it to the list.
I haven't put that in there. That'd probably
Okay.
be great if you have
Yeah.
it.
I saw a few people joining late, so anyone that missed the beginning of the presentation, these are quick and handy to see what the changes were, essentially.
Awesome. Ed, did you have a question or no? No?
Yeah, sorry, just a little late. I was just gonna jump in regarding the work truck and extinguishers. We have a simple rule of thumb with our company, our site. If we're bringing employees to a site and to be dropped off, that's just a passenger vehicle. But if it's going to a job location, job spot, or used for a job, it's kind of automatic with extinguishers and first aid kit. Just to not bother with distinguishing if not, if it's arriving on site to drop off people, that's one thing. But it's participating in work, even just hauling tools and material. It's kind of a simple one for us there.
Thanks for sharing. Okay. Any other questions here? I'm going to get prepped to go on to the next part. Doesn't mean that you can't ask anymore, but okay. And thanks again, Vic and Nimi. Thank you so much for, the effective date. I see that. Effective date was June, I don't know what it was. What was it, June 4th?
No, 3rd.
June 3rd, okay. 2025 was the effective date for the amendments of the act. Same with this bill 38 that we're about to go through. Those were also passed, I think, on the 3rd as well. So again, just wanted to take this opportunity because we were going through the Workplace Health and Safety Act amendment changes. I also wanted to take the opportunity to just update everyone on the new rules for drivers. So this is really about drivers, but because we're in the industry and we do snow removal, towing, it's really good for us to know what the new rules are for. Okay, thanks, Vic. That's what the new rules are for the public in working, driving around winter maintenance vehicles. So we'll go through this. Now, again, we'll stop and have some opportunities to ask questions here too. Let's see. All right. So one of the first things is that tow truck drivers and roadside assistance vehicles, now an operator of a tow truck or other roadside assistance vehicles, are authorized to place traffic control devices on the highway when providing roadside assistance. So that is a new update to the legislation. And what they did is take a look at the definitions. So during the development of this bill, I was also, they did bring in some stakeholders. MTI arranged some stakeholders input in this, and they invited Manitoba Heavy to be part of those conversations as well as stakeholders from industry. So they collaborated and worked on 3 definitions that are specific to these new rules. And one of them is warning lamps. So warning lamps, which defines any of the lamps that are set out in the vehicle equipment safety inspection regulation, in which regulatory work is currently being done. Then the winter maintenance activities clarifies what the, sorry, I just got to admit someone here is coming late. Lost my mouse. There we go. The winter maintenance activities. This clarifies what winter maintenance vehicles must be doing for the rules to be in effect, which includes restoring the highway to or maintaining the highway in a safe condition by plowing, salting, sanding the highway, or by removing or loading snow. Winter maintenance vehicles is also further defined, basically, which sets what a winter maintenance vehicle is, either infrastructure equipment or a vehicle operated by or on behalf of a traffic authority. So as we go through this, you'll see that it will tie in. All right, so just as we kind of went through, basically what they're saying is that winter maintenance vehicles can either be infrastructure equipment, like a grader or a loader, or a vehicle truck equipped with attachments. So regardless, we know that winter motor vehicles can vary. They're big, they're bulky, they come in all shapes and sizes. What are the new rules and how they're applied? So essentially, the amendment easily creates 4 rules for drivers around winter maintenance vehicles. And this slide shows when they're in effect. So number 1, a winter maintenance vehicle is engaged or preparing to engage in winter maintenance activities, as per that definition we just went through. And the winter maintenance vehicle has to have its warning lamps on. So both have to be true in order for this to be in effect. The rules do not apply when a winter maintenance vehicle is traveling to and from a work site or the dump site and not performing activities, right? So essentially, when not engaged with winter maintenance activities and in transit, the rules won't apply when it's doing that. So during that time, basically, they're a motorist, just like any other individual and vehicle using the highway. The rules also don't apply to drivers who are traveling opposite of a divided highway, right? For perimeter number 1 highway. If there's a divided highway, then and traveling in the opposite direction, the rules wouldn't apply to that situation, which makes sense. Okay. So what are the new rules? So forgive me for my graphics here. It's not quite accurate. It is accurate. The information is accurate, but the visual 100 meters there is like the size of a football field. So it's a big amount here. So basically, in addition to complying with the existing overtaking and passing laws already in place in the Highway Traffic Act to keep motorists safe, the amendment sets specific rules for motorists approaching and trying to pass winter maintenance vehicles traveling in the same direction. So that's including and introducing a specific distance that you must stay back from a winter maintenance vehicles. So in the new rules, if you're driving 80 kilometers or less, drivers are required to maintain a distance of at least 30 meters at that speed. So any highway that's under 80 kilometers per hour is going to be 7 to 8 car lengths, which is 30 meters. And then for higher speeds, 80 kilometers or above, you're looking at 100-meter distance between that winter maintenance vehicle. So it's the size of a football field, so quite a distance. And again, when traveling in the same direction, the amendment restricts overtaking and passing at all if the driver is unable to comply with the existing overtaking and passing rules already set in place with the Highway Traffic Act. So that's basically if it's not safe to pass, if it's not clear, if you don't have a good visibility in view, if the vehicle being overtaken signals intention to turn left, all those scenarios will not allow you to pass a winter maintenance vehicle. Or if it interferes with the winter maintenance vehicle activities that are being performed at the time. And obviously, if the view is obstructed by blowing snow or ice crystals. So the new amendments also prescribe rules for drivers when meeting and approaching winter maintenance vehicles at an intersection. So as we know, winter maintenance vehicles often make sudden and unpredictable movements when clearing intersections. And this is also sometimes done at intersections when there's limited space. The new rules requires drivers to slow or stop and not enter an intersection when a winter maintenance vehicle is present unless it is safe, and it won't interfere with the winter maintenance activities. One of the things that is not commonly known by the general, public is that the Highway Traffic Act allows persons, vehicles, and other equipment when engaged with, highway maintenance, they don't the privilege of not following certain rules of the road. So, for example, in this scenario, a snow plow can cross a solid line in the highway when they're clearing snow, and a loader can move around and clean an intersection when the traffic control, like the light is red, and they're allowed to do that legally. And a lot of motorists don't know that. So. Sorry, I didn't advance the slide there when I was chatting about that piece. Did I miss up something there? Yes, I did. Sorry. This slide, I got my my information mixed up here. So just to clarify, this one is for when drivers are to proceed with caution so they don't collide with the winter maintenance vehicle or interfere with its operation. So very straightforward there. And they, if the winter maintenance vehicle is clearing the center line of a highway, a driver must leave enough space so that they don't collide with the blade. And then this is what I was referring to with the intersection, that, the winter maintenance vehicle does have the right, even when the light is red, and drivers have to proceed with caution. The question, let me see, I just saw a question in the chat about where you have that in writing, I believe. That would be in the Highway Traffic Act. Oh, it says MPI does not accept this. I can see if I can dig that up for you, Matthew. But it would be in the Highway Traffic Act, I believe, but I will verify and definitely get back to you on that. Let's see, I have another question here. I had a question about the Workplace Health and Safety Act. We'll come back to that at the very end, Jen. Okay, so those are all the updates in for the winter maintenance vehicles in that bill. And I just quickly wanted to display this on the screen as well. I don't know how many of our members this affects, but there were also some new regulatory changes and some regulatory changes that just came into effect about commercial vehicle operators. So in January 1, 2025, provincial regulatory changes affected operations of regulated vehicles. So buses, motor vehicles, and trailers with a weight of 45 100 kilograms or more. So who are required to hold a safety fitness certificate. So one of the big things is that, we have enhanced safety oversight. So authorities now can refuse or assign a safety fitness certificate based on an operator's safety record. And so this ties into high-risk operators and is supposed to, improve overall safety. Operators have to carry a physical copy of their safety fitness certificate in the vehicle while operating in Manitoba for immediate verification if authorities ask for it. And then July 1 of 2025, all regulated vehicles must clearly display the registered owner's NSC number for identification and accountability there too. And then chameleon carriers. So, just for information's sake, companies attempting to evade past safety violations by reopening a new name, they've just strengthened the enforcement of this. So you basically just can't close down business and open up under a new name. Any questions there? I'll go back to Jen's question right there, but that really concludes those big updates. But I'm going to jump in here. Definition for lacerations. I don't recall the report, Jen. I put in the link above. The very first comment in this chat is a link to the report for the committee that reviewed the Act and regulations. And when I got this role at Manitoba Heavy, I was included in that committee, but I came partly through. So I have reference to the last half of that committee review, but it went on for over a year, and there were hundreds of public submissions on Engage Manitoba that committee reviewed. And so I apologize, but I don't recall specifically the discussion for lacerations, but if it was, it will be in that report. So I would open up that report and do kind of a search for lacerations, and it should pop you to that if indeed it was something that's been put towards consideration for legislative changes. So just again to remind everyone, Bill 29 were the amendments to the Act. That's what Nimi just went through with us. And BIC supplied a link to an FAQ section outlining all the changes in the Act. And then the other piece is the amendments to the regulation. And the regulation amendments have not been passed. They're with the minister and they have not been passed by legislation yet. So they're still being kind of discussed and, deciding on what direction to go in. And we don't know when that'll be, but I've got a question here, not related to the current amendments, but as an independent auditor, whenever I ask workers, supervisors, safety reps, etc., they rarely know the fourth right. They usually say discriminatory-free workplace related to gender, race, orientation. Protection from reprisal isn't a vernacular that most people use and isn't easy for people to remember. Fourth right should be rephrased. Has it been brought up? I don't recall that being brought up. I recall it being brought up to, by folks in industry and other industries that I've worked with. I think that just, goes to training and rephrasing it ourselves. That's what we can control is, what is that? It's basically, you can't be punished for bringing up, your rights and refusing dangerous work. However, at the legislation point and the policy writers, I don't know if that's been under consideration. But when it is up for review again, definitely look to make that recommendation. I was really impressed with the process, and I work with a lot of jurisdictions across Canada and have been hearing how they do their reviews for the Act and regulations. I was really impressed that Manitoba, involves the public, and really impressed at how quickly things move here, or have moved this round, because I know other provinces that have been held up and they have, like, you know, 1 or 2 changes passed at a time, and we're talking years and years of waiting. So, I don't know, just an aside. It was just an observation. Anything else? No? Okay, well then I'm just going to thank you all for joining us today, and really appreciate it. Obviously, this is a topic that folks are interested. We had a lot of people register. We did also record it, so we're going to have it posted on our website, and we will include it in our Safety Scoop newsletter. And I'm trying to think, when the regulations do pass, like we provided in our newsletter kind of the links to the reports as they're presented, but once they do pass, we will be bringing you another webinar, something similar. We're going to try to pull. There were a lot of recommendations submitted, but we're going to pull what, you know, will affect industry, and we'll try to bring you, you know, all that information once it does pass. And so stay tuned, and if we have any updates, we'll definitely share. We're trying to do these webinars. We just had one on contractor management, I want to say 2 weeks ago, but we're trying to do these more regularly, definitely one per quarter. It's a busy time for industry right now, so this will probably be the last one until things slow down. But if you have any ideas, you know, please drop me an email. I'm going to stick it in the chat, my email address. But yeah, if you have any ideas and topics that you're looking for, we can bring in industry experts, and, you know, provide you guys answers with your challenges and things that you're looking for information on. There we go. There's my email. So please reach out, and thanks again for taking some time this morning, and listening in on some of the legislative updates. All right. Bye, everyone.